So please
Continue.
start. The floor is yours.
Thank you very much, Dragica. I'm very pleased and honored to be here and to share with you some food for thoughts. Just feel free to interrupt me anytime and don't be shy, please, because I have the full screen with the slides, so I cannot look at the chat at the same time. So please do feel free to speak and interrupt me for whatever question or doubt or curiosity, whatever thing you may want to ask. So we heard several interesting things from my colleague Zara and from your questions. You focused on the concept of gender, on the concept of family. So I want to begin with the link with her presentation, and I want to focus first with you on why would a gender reading of family law be important? Well, first of all, as it is quite intuitive, because family is the embryo of society, and it is actually the mirrors of a country's culture. The Germans from the Pandic school would say the Volksgeist, meaning the spirit of the people. And family, as you've learned from the previous speech, is one of the institutions that have been and is actually more influenced by the traditional divisions of roles between the genders. I would say that at least the majority of inequality problems in this field in family law have been a reflection of two ideas, or maybe the combination and the possible clashes between these two ideas. And these ideas are the idea that the marriage should actually be the ambition of every woman as a matter both of self-realization and economic realization as well. And the other idea is that every woman should waive her professional ambitions for the care of the family and of the family home. Then, equality is the key word, of course, and the gender equality have been actually the flagship of modern family law. And it is the pillar of all the reforms which have been enacted by the various, at least the various European states starting from the 70s. And it is in the very attempt to implement this principle that courts actually have been responsible for an important evolution of family law. And the outcome of this evolution, as we will see, has been actually a strong individualization of family law. What do I mean? I mean that such evolution, which is no more national, but has gradually acquired a transnational dimension. I'm thinking most of all of the European Convention of Human Rights, which protects family together with private life, and that is very significant. And also I'm thinking of the principles of European family law. Well, the model coming from those international sources is the one of a strongly individualized family law. There has been, if you look at European Court of Human Rights case law especially, you can notice that there has been a shift from the conception of family as an institution transcending individuals, because the family is important for society, to a conception of the family as the expression of individual personality. So family as one of the formations in which the individual personality can develop. Okay. Along with this, there has been the acknowledgement, and this comes from this case law again, of gender as a right, and not only a right, but a fundamental right, because gender became a component of personal identity. So basically, whatever my gender is, I have the right to form a family and even, but this is rather more controversial, the right to be parent. Now, these 2 points, in my opinion, are crucial for understanding current family law and should be really the background of whatever gender-sensitive reading of family law. Well, you can figure current family law as a matter of striking a balance between the struggle for individuality on one side and the quest of the best interest of the family, which is also the best interest of society, on the other side. Then we have had several achievements in terms of gender equality in family law, as my colleague Zara has mentioned, but we should also realize that inequalities still persist, even in, let's say, more advanced systems, as Dragica mentioned. And those are inequalities which are not much in the law in books, let's say, but rather in the law in action, in concrete everyday life. And actually, these inequalities persist as a product of systemic shortcomings, we could say. So welfare, labor law, and it is a product of such shortcomings which do not come from family law, okay? They come from other areas of the law, and they come from society in itself, from all the aspects you have mentioned with my colleague. And which is something that came out also in the previous speech. Besides, these inequality problems are magnified by cultural divergences, and namely the spread of what we could call alien family models, meaning models of family that were not born in our value system in Europe, in the European system. So the cultural cross-contamination plays a fundamental role in this domain as well. Of course, if I'm going too quickly or whatever you wish to ask, please, again, feel free, okay? Then, in this light, in this framework, a gender-sensitive reading of family law could be crucial, at least for 2 tasks. First of all, for identifying such shortcomings and even finding solutions capable at least of reducing them or mitigating them while we wait for legislative interventions. And the second task would be to avoid the risk of what we could call reverse discrimination. Do you know what I mean by reverse discrimination? Does anybody have an idea of what that may be? Well, actually, we should say that we need, with our gender-sensitive reading, to avoid a blind application of equalizing rules, because this can lead to an overprotection of one of the spouses to the detriment of the other. So while we're willing to protect the weaker party, we can reverse the thing and making it become the stronger party and create new weakness upon the other party, basically. We will see that with post-divorce maintenance.
So overcoming the discrimination of the weaker one, turning towards discrimination of that one proposed to be the stronger one. Ivana wants to add something.
Yes, I just wanted to check with you whether I have a right example of such case. For example, here in Serbia, in most cases, parental responsibility in case of divorce or separation of the parents of the child is given to the mother of the child, and perhaps that could be the example of the overprotection of the mother, being the woman, in the present situation here in Serbia. So I just wanted to clarify that, and thank you in advance.
Thank you very much. It's a very clever remark and a very clever example. I totally agree with you. we should have actually, in order to avoid this reverse discrimination, a case-by-case approach. So a more flexible system granting joint custody, for instance, and a case-by-case analysis. Because to say that the mother is the person who is most suitable for keeping the children, etc., is a stereotype in some way, is a gender stereotype. And so we should adopt a more flexible approach and study the situation case by case, and I would say promote as a rule the joint custody. Then the custody upon one parent only should be an exception. And that is actually, that has been our evolution in Italy, for instance. We moved towards the rule of joint custody. So the children have the right to spend equal time basically with both parents. And then if there are, but there need to be exceptional reasons for derogating from this rule, exceptional reasons like the father or the mother is not capable of taking care of the children and so on. I don't know if I answered to your question.
Yes, yes, you did. Thank you very much. And another example, from what I see, you have also said it in the slides in the presentation, could be the situation in the United States when, after the divorce, the women usually tends to be given a lot of money as a sum, which results in the separation of both the husband and the wife. And I would say that this also could be an example of the reverse discrimination in our everyday cases and world.
Absolutely, and I put it in the slides afterwards, but I can talk about this now, and then we will skip it in the final part. But we had, for instance, in Italy as well, this rule for which we should give to the weaker spouse after divorce the amount of money which is enough to keep a certain standard of living. But the point was, what does enough mean? Well, that was a huge debate, and in the first phase, judges tended to say that enough meant keeping the same standard of living as in marriage, and that ended up transforming post-divorce maintenance in a sort of life insurance. Because if you manage to marry well, even if you didn't work, you've never worked in your life, but you managed to marry well, then even if you were married for just 2 years and so on, you had a life insurance. You had really a huge amount of money because you had to keep the same standard of living as you had in marriage. And then there was a shift. There was a shift from this criterion, because this, of course, turned into reverse discrimination and did not encourage the, let's say, weaker spouse to be again in the labor market and to gain its own independence. Any other remarks by anybody?
Can I also have the floor once again?
Yeah.
No, I just wanted to say that here in Serbia, when speaking about the maintenance or the alimony of spouses, we have some rules that are related to both the spouse that should be the one that is obliged to give away his money or his assets. You can hear that I said his, and that's probably something that I did unconsciously. While on the other hand, the creditor is also the one who has to fulfill some conditions in order to exercise her or his right to maintenance. So I would say that here in Serbia, perhaps such situations are regulated in a quite good manner. I just wanted to add that as well.
That's good. That's good. And we can also talk about this later when we talk about the consequences of divorce or separation, but that's very interesting. Any further remarks by any of the students? Okay, if not, let's dig into the main aspects on which such gendered reading should focus. First point, let's say, equalizing technique is freedom of marriage. Freedom of marriage has two components. First of all, equal access to marriage for both spouses and freedom to choose the other spouse independently. You know that in several cultures, I can give you the example of traditional Chinese law, for instance, but there would be several other examples. It is the father who chooses, the father of the family, the chief of the family who chooses the spouse. So in this perspective, gender-sensitive family law should fight against the problem of arranged or forced marriages, which is a problem, again, magnified by cultural cross-contamination. Then, second point is the freedom not to choose marriage, the freedom not to marry. That is to say, the freedom not to choose marriage as the family model. In this light, gender-sensitive family law should fight for family pluralism. Not only one model of family, not only one conception of family, but multiple models of family. Then, talking about this second point, actually, we are facing a milestone with this freedom not to marry. We have witnessed through the centuries to an increased sensitivity of the law for de facto relationships, for cohabitation, that is to say, for unmarried couples, as you wish to call them. There are several names to call them. And this is a milestone because the formal and substantive equality of the spouses would be severely undermined if marriage was the only possible choice. I mean, if I can only marry, if I want to build a family, if I want to live in a couple without living in sin, or if I don't want my children to be treated as illegitimate children, then if marriage was the only choice, then I would not be really free to marry. So that's really a milestone. We should say, always, because we must try to adopt a realistic approach, we should say that prejudice still exists against unmarried couples and unmarried in couples having a family, which are deeply rooted, especially in certain social or geographical or religious contexts, even in Europe. And those prejudices affect mostly women, we should say. Because as I anticipated at the beginning, women, it is not so rare that women are educated by their families in the belief that marriage is the key to full self-realization and one of the paramount goals in life, and an absolute must in case of pregnancy. You know, in Italy, especially in the South, at the beginning of 1900, etc., one thing which was very in vogue was the so-called reparatory marriage. That is to say, there was a young woman pregnant, and so her parents forced her to marry with whoever, just not to give birth to a child without being married. But I would say that nowadays this is only a social prejudice, which is by no means supported by the law. If you have a look at European legal orderings, at least, well, they all have gradually removed the obstacles that could lead couples to consider marriage as the only real alternative. I can give you quick examples. Of course, we could spend more time on this. Equality between children born in the wedlock and born out of the wedlock, both in terms of family law and in terms of successions law. Possibility for children born out of the wedlock to sue the biological father for the ascertainment of paternity and suing him for compensation of damages and the payment of past and future maintenance. Extension to cohabitants of welfare rights, of compensation rights, meaning I have a cohabitant and he is killed in a car accident. I can claim for compensation for moral damages because cohabitation is an interest protected by the legal system. Retirement pension rights. So if my cohabitant dies, or if I die, my cohabitant has the right to my retirement reversion pension. And visit rights, like visiting the hospitals. So we could say that, at least from a legal viewpoint, married couples and married couple are equal, in fact. Then if we look more specifically into the systems, we have still inequality problems here as well. Well, first of all, not all systems have enacted a specific and comprehensive regulation of the relationship between cohabitants. So marriage is utterly regulated, cohabitation is not. Why, in your opinion? Why is it so? Why this choice not to fully regulate cohabitation, unlike marriage? Anybody?
I would probably guess that it is a way of safeguarding the traditional values and norms that are deeply rooted in the European society. I would guess that that is probably the main reason for doing so.
Yeah, on one side, surely the reason is that one, so we cannot extend.
Sorry,
Yeah,
sorry.
please.
Maybe on the other hand, there are no so much of empirical data. I mean, how to regulate every possible problem in that sense.
Okay, well, actually, there is case law on the point. There is, of course, this reason of preserving, especially the rules on marriage, which cannot be touched and applied extensively to cohabitation. There is a sort of a reluctancy in this point, and case law is quite firm on this. But think of yourself. Imagine that you want to start a cohabitation, but you don't want to get married. Why would you choose cohabitation instead of marriage, besides from religious matters? I mean, if it's unregulated, why would you choose it instead of marriage?
So maybe there are psychological and social reasons, like people are disappointed in marriage or have high expectations, but easily get disappointed, etc.
Okay, and among those psychological reasons, I would also mention the fact that cohabitation is not regulated, while marriage is. So it feels like a more important step also for this reason. So maybe I'm choosing cohabitation right because it is not regulated by the state, and I feel freer to be part of a cohabitation. This is one of the reasons why several states chose not to provide a comprehensive regulation, to leave it to the self-regulation of the cohabitants. We had principles at the European level, but not all the states adopted them. So generally speaking, the regulation of such aspects as the distribution of property or the management of the couple's property and the contribution to the family ménage are committed to the cohabitants agreement. Okay, so they are left to their agreement. Then in some cases, like for post-cohabitation maintenance, the agreement is the primary source of the regulation, but then there are some legal default rules applicable for filling the gaps. For some other aspects, like property distribution, the agreement is likely to be the only source of regulation, meaning that if there is no agreement, there are no legal provisions applicable, no default rules applicable. So we are cohabitants. we haven't we haven't signed a cohabitation agreement. The couple breaks up. What do we do? What do we do with the house? What do we do with the assets? Well,
Excuse me, can I add something based in Serbia to share some experience of cohabitation? In recent years, more people are likely to be in this kind of, as Nemanja mentioned, the psychological not giving attention to the institution of marriage. And also, it is, even if it's not directly regulated, it has some like articles that say that also couples in this cohabitation have some rights of inheritance, child custody, etc., if under specific circumstances. So that's why more younger generations are choosing this because of more flexibility and gives them more space in their personal lives.
thank you. Thank you for these clever remarks. And as you see, as you mentioned, you have regulations for child custody because family unmarried children of unmarried couples are equal to children of married couples. So the protection must be there for everybody. You mentioned inheritance rights, but you haven't mentioned property distribution, because that is the aspect which is, I don't know if it's the case in Serbia as well, but normally
Yes, it is. Yes, I forgot to mention that also.
Okay. So it's not regulated for cohabitants in Serbia, right?
I will just jump in to say the smaller the city or town, as we go to smaller places, there are less and less examples of cohabitation, meaning people go right into marriage with much younger age. So it's a big geographical difference. I mean, rural places have much higher number of young married people.
Yes,
Yeah.
and also I wanted to add, I'm just researching if I am right, but in the our law, that family law, it says that this cohabitation has to be this legal standard, like a permanent community or something. I don't know what is the right translation, like a lasting community, more lasting community. So that's has that is interpreted in every individual case. So
I'm sorry for barging in, but I just wanted to correct what has been said regarding the division of assets. The unmarried couples are equal as married couples here in Serbia. That was one correction that I wanted to make. And unmarried couples have no inheritance rights among each other like married couples do. So I just wanted to make that correction and to be clear, that's how it is regulated here in Serbia.
Okay. So there are differences in this viewpoint. In Italy, for instance, there is no legal regime, like no community of goods for unmarried couples. So there are no rules applicable, just to keep it different from marriage. So you see that the solutions might change from state to state. The problem is always the same, but the solution might change from state to state. But
Excuse me, I have
yes.
one question regarding Italy.
Yes.
So even though the couple fathers becomes parent in cohabitation, they still don't have any right to assets, their assets of their spouses, even though they have a child. So nothing changes with the child, yeah?
No, nothing changes with the child. As to, of course, as to the assets. Yes.
Okay.
Yeah. There are the children are equal, so maintenance of the children and all that is equal as in marriage. The only point is that there is no regulation about the distribution of couple property.
Okay.
Then one thing changes. One usual scheme for cohabitants is that there is one of the cohabitants being the owner, the exclusive owner of the house, and the other cohabitants may not be the owner. But if the other cohabitant has the custody of the children, then even though the first cohabitant is the owner, let's say the male is the owner, he cannot throw away from the house the other cohabitant because of the children.
Okay.
So yes, in this respect, it changes.
Yeah.
But this is intertwined, again, this is not family law. This is intertwined with contract law, with the contract of use in this case. So the contract of the landing of the house. And what is important, and we will say it in a moment, is that family law in these respects, in respects of unmarried couples, and for the need of granting gender equality, is influencing all the other areas of the law, property law, contract law, because cohabitation and family are becoming grounds for contract, grounds for justifying transfers of property, and so on. But this creates problems. I don't know if there were other remarks, but we will further develop this subject. I just wanted to focus on the problems in terms of equality that this might raise. First problem is, okay, we leave it to the agreement of cohabitants. But what if they have no equal bargaining power? I mean, one can be more in love than the other and can be blinder in a way than the other. And so the other can prevaricate in the negotiation of the agreement. The other problem is, if we don't have default provisions, like for the distribution of property, etc., again, this enhances the risk for the weaker party to be placed in a worse position than he would be if he was married. First problem, so the bargaining power concern. Well, here we should turn to contract law, because I mean, if there is no specific legislation on the negotiation of the agreement, well, the only form of protection available would be the one provided by general contract law, and namely the rules on defects of consent. You know, duress, meaning I was forced into the agreement; mistake, meaning I was mistaken, I made an error on an essential element of the agreement. Fraud means that the other party convinced me of something and led me to believe something which was not true. And the other defect of consent is the lack of capacity. But I mean, there are strong defects that are very narrow. They are not suitable for a simple gender-related weakness. Okay, I mean, just because I'm a woman and I feel less powerful than my male cohabitant, this cannot be incapacity or the others. So this is a problem. And the second problem, that is to say the lack of standards of the default rules, again gives room to contract law, basically. And the only way is to check if the contract is compliant with mandatory provisions, public policy, and also in some systems like Italian or French, morals. But then, so this is for the agreement, okay, we can check it. We can check if it is compliant with the system, but no more than that. But if there is no agreement, then we have to turn to traditional private law. Namely, contract law. For instance, I purchased a house. I am a cohabitant and I purchased a house with the money which was coming also from my cohabitant. But the house is mine because I bought it alone and it's mine in the registers. So what can we do? What can we do if the other party contributed to the purchase of the house? or property law, when it is a problem of selling or dividing the property which has been jointly purchased, not purchased by one of the cohabitants, but by both together, and also restitution law. Think of this, namely unjust enrichment. Think of this. There is one cohabitant who is the exclusive owner of a piece of land. I am an architect and I work or an engineer, so I can build things, and I use my labor energies and also my savings for building let's say an extra floor or a terrace on the house owned by my cohabitant. Well, for land law would say that, at least in Italy and in France, would say that the owner of the land gets the ownership also of what is built above or underneath the land. So I put my money and my efforts in building the terrace, but the terrace will go to the exclusive ownership of my cohabitant. Everything is fine if cohabitation goes on well, but what if cohabitation breaks up? In your opinion, what happens? Can I take the house back because I use my money for it? Can I get something? How does it work? And here as well is gender weakness, because maybe I did that. I knew that he was the owner, but I said, okay, but I love him so much. So, I mean, no need to worry about that. I will give this money because we will live together for forever. What do you think would happen?
Well, there should be some kind of compensation for that and some kind of restitution, because it will be unfair and unequal to not be, because if you contributed to that with your money, with your resources, it's by the law necessary to provide the necessary compensation.
Okay, but under what?
Would
First,
I
I'm sorry. One important part is there any proof that you participated or you paid some amount of money? This is also important.
That is also important. If it's a bank transfer, it's easy to prove, but if it's on cash or something, it's difficult. Yeah. Thank you.
Of course. But then you say compensation, okay? This is the intuitive answer of everybody. But
so I would say touch nothing, meaning it's not defined quite well as a social institute. That type of interhuman relationship, and law should be out of it.
And one more thing that I wanted to add, if I was in that situation, cohabitation, I would definitely put all on paper, and just to be sure that my resources are protected.
okay. But my
Necessarily like a marriage contract, but some kind of other contract that secure my.
Okay, yes, of course. That is the
Or
purpose of
something
it.
they have in United States. They have something like this. There is something like this in United States. Such rule. They have some. I don't know. They call it like prenuptial paper, something like this. I don't know exactly, but yeah.
Prenuptial agreement, perhaps. Yeah, that is similar to the marriage contract that our colleague was speaking about. Yes.
Yeah, but also in Italy, you can have a cohabitation contract and set those aspects there. But the problem is, I am the weaker cohabitant. I say, okay, we love each other. We don't need cohabitation contracts. I mean, in the US, this normality, okay, in the US, they make agreements for everything. Prenuptials and all that are common. In Italy, no, for instance, because there's always like we are reluctant to contractualize everything. We say we love each other, we don't need to put it black and white. So this is why it's important to see what the protection is. And what I wanted to ask you further is, okay, you said there should be a compensation. Under what? Under tort law for instance, or under what? Because if you want to have compensation, then you have to apply tort law or you have to apply contract law. What would you apply?
Maybe civil law, something
Civil law, but what?
family law.
No family law on this point.
I want that. Yes, I would say it's a tort law because we have something that, for example, when we conclude or come to an agreement, it's not necessarily to be in paper. It's enough just to have some proof, consensual, or for example, we have Viber messages, and we agreed that I will pay, I don't know, 5,000 euros for that house. And we said, okay, I will pay you. We don't need to be like in written, formally written form. So maybe something like that would be suitable for this situation.
Okay,
I would also like to add property law. I think that property law is of great importance for handling issues such as this one in the present case, because there is a possibility for the unmarried couple to make an agreement that both of them actually will have sharing parts on the house, or for example, one of the persons forming part of the couple will choose to have compensation in money, while the other will have sole ownership on the house, for example. So I would say that property law is of great importance for handling this issue as well.
Absolutely. The point is again that you have to make an agreement, because if you haven't made an agreement on this, then you have no property law protection. No default rules and no agreement means no property law protection. So you cannot have the house back because this is against property law and there are no specific rules and no agreement. You said tort. Well, but for tort law, there need to be a damage and a wrongful damage. And here, what triggers that you lose the house is the breakup of the cohabitation. But this cannot be a wrongful damage, because I mean, breaking up a cohabitation, everybody is free to break up the cohabitation. That is why unjust enrichment comes into play. You know, that there has been a transfer of money for buying something. This transfer enriched the other person, enriched the other cohabitant, so there is the enrichment. I got poorer because I used my own money. The justification for all that was there, and the justification was cohabitation. Now cohabitation is not there anymore. Then this enrichment became unjustified. So I can get my money back as for the regime of restitutions. Those are very technical aspects. I just wanted to give you an idea. But those are gender equality problems which the law must face.
I'm sorry for interrupting. I
Yes.
just wanted to make a clarification. When speaking about property law, I had in mind the regulations here in Serbia and the provisions in regards to property division. So I wasn't clear on that. So just wanted to clarify that.
Okay. Yeah, of course, if you have like in Serbia property rules, I mean, in marriage, this would be resolved by property rules, for community of goods rules. So if you have them also for cohabitation, then there is no problem, and that could be a clever choice by the system. If you don't have them, then you must turn to other sorts of remedies. Then, moving to married couples, and Dragica, please tell me if I'm expanding too much on. Please tell me, okay? If you please tell me how much time I have.
Let's make the common plan together with Ivana. So we are supposed to work until 1:45. Ivana can shorten her presentation to, let's say, half an hour. Maybe we can also shorten the break. So it means that, but maybe so let's try, Letizia, that you complete your presentation until in I don't know, I can't concentrate, 10-15 minutes. This is very interesting, but try to sum up
Yes.
in 15 minutes. It means then with a short break, Ivana will have about 40 minutes, but if less, she will agree upon. But so try, so
Okay.
15 to 20 minutes.
Okay, no problem. That is why I
because
asked.
of the discussion and the
So,
questions.
but this is very rich discussion, and Ivan also says that. So do not hesitate. Use the time 15, 20, 25 minutes.
Okay,
Be
okay.
flexible, but try to complete.
I will. Okay, so these were unmarried couples because of the freedom of marriage. Now we have the problem of married couples. As you know, the first equalizing achievement was that each and every legislation in Europe provided for equal and mutual rights and duties of the spouses. So each of them has the same rights and one towards the other, so perfectly mutual. Then one very important achievement has been the recognition of the same dignity to domestic work in the contribution to the family menage, so that there cannot be a blackmail by the husband saying, I am the one who decides everything because you don't work and I do. No, that's not true, because domestic work has the same dignity as external work. Both spouses have the same capacity of disposing of the marital property, and in order to sell some goods of marital property, you need always the consent of the other spouse. These are the equalizing provisions. We've seen that the first point was freedom of marriage. Well, there is also the opposite right, which is freedom from marriage, meaning we have the equal freedom of breaking it. Each of the spouses have an equal right to break the marriage, obtain separation and divorce. So each of the two can claim for divorce on the same grounds and without the need of the other spouse consent. Okay. Together with this, most legal systems have moved from a fault-based separation or divorce to a non-fault model. I mean, before, at a certain time, if you wanted divorce, you needed to prove a fault of the other spouse. You need to prove adultery of the other spouse and all that. Now you just need to prove that you cannot go on. The irretrievable breakdown of the marital relationship. This is also an acquis of the principles of European family law. Then I will move quickly on these points because there are more specific provisions, of course, and case law about this non-fault based separation and divorce is very rich, but we just skip this aspect. Consequences of separation and divorce. Okay, freedom to break from the marriage, but then what happens if we break free from marriage? Because this breaking free from marriage may mean for one of the spouses being in a detrimental condition. Because when I was married, I could count on a double salary, on a certain stability. What happens afterwards? Okay, then here we need accurate assessment of the provisions of the systems. There are two techniques for regulating the consequences of separation and divorce, which are the division of marital property and maintenance, okay? Allocation of the financial assets. It is by moving these two strings that we can equalize the regime of the consequences of separation or divorce. Then, distribution of marital property and post-divorce maintenance. Community of goods was the first technique. I mean, in a time where women were considered the weaker sex, most legislation attempted to remedy this inequality by establishing as default rule the community of goods. Okay, so I'm the woman, I don't work, so I don't earn anything. So it's obvious that everything, all the assets we have been bought by my husband. But I can have a half of it just because I was married with him. Okay, even though he owns everything. This is the ratio for community of goods. I am protected because I will end up with something, with half of what my husband bought. And this is right, this is fair, because he was the only one who could work and buy goods. This is the logic behind it. We have in Italy community of goods as default regime. In some systems, there is no default regime, but the courts have power to distribute the marital property between the former spouses as they wish in order to rebalance the situation. So for some systems, especially common law system, this is the first way of rebalancing. The judge can distribute all the assets in order to rebalance the position of the spouses. And only if this is not enough, they will resort to maintenance. So they will try and solve everything with this technique, with the distribution of property. If it's not enough, because inequality still persists, then they can provide something for maintenance. What is the problem about maintenance? The problem about maintenance is that it is an ongoing obligation. So, I mean, normally it means paying a certain amount of money periodically. But if you pay it periodically, then this means that it's ongoing. You will always have to beg the other spouse to pay your maintenance, and the relationship will never end in some way. Okay, this is one of the problems. We will see what we can do with that. And then the other problem is, how should we decide whether one of the spouse has the right of maintenance, and how should we calculate the amount of money due? Okay. The original trend in Europe, in several European countries, was to be based on 3 parameters. Compensative criterion, I mean, I should calculate the amount of money by looking at what the person has sacrificed, and so the amount of money should take into account the sacrifices that the person made for the family. Second parameter was punitive criterion, so if one of the spouses broke up because of adultery or because it was in fault, then he will have to pay more, just to simplify. And the hardship criterion, so if there is a spouse who is in need because he doesn't have enough means to live by, then he has the right to get maintenance. And this maintenance should be parametered, should be calculated in relation with what is enough to live by. Okay? Okay, then one of, as I mentioned to you before, one of the most controversial issues has always been establishing this threshold. What does live by mean? Okay, 2 options, as we said before. First option is we should grant the same standard of living, but this risks entailing reverse discrimination, as we've said. Okay, and also if the allowance is periodical, as I told you, the former spouse risks to be bound to each other's by a sort of economic dependence for a very long time. For those reasons, the approach of the courts and European legislations has changed and moved towards what is called the clean break philosophy. What is that? Well, the underlying idea is that the weaker spouse should be encouraged not to live as a parasite of the other spouse, but to become financially independent and also morally, of course, as soon as possible and break the ties with the other spouse. Okay? Break the ties. This means, okay, if you need maintenance, because you are in hardship, because you made lots of sacrifices. If you need it, you will get not the payment of a periodical sum of money, but the payment of a lump sum once and for all. The problem is it's difficult to make a prognosis on what this amount should be, how this sum should be calculated. Then this approach has been criticized from a gender perspective. First of all, it has been observed that economic independence upon divorce, or at least within a short time from that, neither grants gender equality nor this rebalancing of the positions of the spouses, because women continue to be awarded lower salaries. So it's not the same. And they also have more difficulties to re-enter the labor market and find a job capable of providing them with self-realization and adequate salary. And this is because maybe they have spent several years being away from the labor market because they devoted everything to the care of the family. So they have difficulties in that. Then,
Letizia, just a second. So these are reasonable critical arguments. But again, on the other side, I think that feminist perspective could be used in an opposite sense, that this breaking the economic dependency or pushing or stimulating the weaker spouse, most often the female one, to be more active, at least to get some, maybe lesser extent of economic sources, maybe not enough, but still to become independent. So it also can be the feminist argument. So to break this patriarchal basis of the reaction of the weaker spouse. I was not very enough clear, but I think you understood me.
Yes, I totally agree with you. In fact, if we adopt the right perspective, these arguments can be overturned. And they have been overturned in some systems, and namely in the Scottish one. The Family Law Scotland Act of 1985 has set some principles, some guiding principles for the judges to solve these problems. Fair sharing of matrimonial property, balancing principle, fair sharing of the burden of childcare, readjustment principles, and relief from financial hardship. I will make a synthesis of those principles to answer your question. And then, of course, if you want to get into depth with some of them, we can discuss it afterwards. The point is that according to the balancing principle and the mix with the other principle, the answer is, okay, we shall calculate the amount of money, this lump sum due for maintenance, according to what the person would need to adapt to the new situation and to be financially independent, but not to have just enough to live by, but financially independent according to what she did before marriage, what her ambitions were, what was the career she had started before leaving everything for the family. So there is a compensatory criterion, we could say, because she normally but it could be also he, sacrificed her ambitions, her career for the family. So she needs to be compensated. And the value of this compensation, the one which would be capable of really rebalancing the situation, would be what she would need to restart what she have waived for the family. So if she started studying medicine or I don't know what, the compensation should be parametered with the cost of beginning medicine studies again, university, and all that. So let's say financial provision must be reasonable to enable the other person to adjust to the new situations, and also to retake what she would have get if she wouldn't sacrifice everything for the marriage. And then of course financial hardship. So of course if she is really in serious financial hardship, the maintenance should take also this into account. Okay, so I would say that we could end up here if I stayed in the 15 minutes, and of course I'm open to whatever question you. I just wanted to tell you one final remark. I mean, this latter approach, in my opinion, is strong and has many strengths. Because it rebuts the arguments we've mentioned before, and because it's gender neutral, meaning the concrete assessment of the circumstances of the case and of the effective degree to which the spouses committed themselves to marital life really allows courts to overcome this sort of binary male-female antithesis and really focus on the personal features behind genders. And so this can be particularly helpful, not only for male and female alternative, but also for separation and divorce proceedings involving transgenders or same-sex couples. Thank you very much, and I'm here for all your questions.
Letizia, Zara and you mentioned gender neutral approach, but implicitly, and I think that it should be explicated as well, it is gender equality sensitive, neutral to a certain extent, but still gender equality sensitive approach. So it has to be clear it's not gender neutral in a traditional mainstream understanding. So please clarify that.
Yes, you're right, Dragica. Yes, by gender neutral, I meant that it is sensitive towards all of the genders. That was the point. Neutral in the sense that it does not make differences or discriminates any gender. Right. Thank you for your clarification.
Other questions, something in the chat? Maybe now you can check, because I can't. Maybe you can check whether there is something in the chat.
Okay, I just try and reopen the window. Just a moment. Okay, now I will. No, I see no questions in the chat.
Could you sum up, if you feel like, if not, just forget about, sum up this analysis in a sense to say what are achievements from the gender equality perspective and what still is to be achieved, and what are regressive eventually steps in regards of gender equality in this field of right to marry, right not to marry, and divorce and consequences.
Okay, so I will try and be synthetic. In my opinion, as to the legislation regarding family, really we have achieved equality. From a formal viewpoint, I would say that the only problem would be to cast light whenever there are no specific rules, like in unmarried couples, it would just be a matter of regulating, or maybe just cast light on traditional institutions and how private law traditional institutions can be read in a gender sensitive way. I would say that the inequalities still persist outside the family legislation context. So as I said, in welfare, in labor law, probably, and in society, as a cultural matter. So in the mentality of people, it's that should be changed. But this requires a change of society, change of mentality, change of all the state institutions which revolve around the family. So it is something exogenous from family law. I mean, if we mean for family law, the private family law. Okay.
For example, I'm not competent, I'm far from that, but from the life experience, I would say that in regards of the alimony for children after the divorce, and in most cases female mothers get the custody. In our society, there is so alimonies are low, and the trend of impoverishment of the female divorced persons has been a very general phenomenon. So comparatively speaking, what would you say? Or maybe some of our participants disagree with me, but that's due to my knowledge from the life experience.
From the viewpoint of Italy, as I told you, there is this rule of joint custody. So I would say that in the custody of children, but that is not my. I do not deal with minors normally, so that is not really my topic. But I would say that this shift towards joint custody has equalized much more the couples. So then, of course, there are problems also in this field, namely the fact that, okay, both parents share the burden of childcare, as in the principles mentioned in Scotland. But then again, there are problems coming from outside, meaning if I am the woman and I have to go into the labor market again, I will have less time to take care of the children. So a shared burden would not be ideal for me, maybe, because I need to work hard, because I cannot afford to have somebody for taking care of children. So that is why I was saying that we should have external aids, external from family law, for these reasons. And also in terms of kindergarten in hospitals or in the workplace, and these kinds of aids. Right. And I forgot to say, when you asked me about what can be improved, etc. In Italy, for instance, and I am part of this commission for the reform of family law, and this is what I study actually. I think we should move towards the Scottish system. So not setting criteria as general as the live by criterion, but set principles in order to help judges to adapt really and adjust really the provisions to the concrete situations.
Fantastic. Thanks sincerely very much. This was a great presentation, and I think also the discussion and a very relevant topic. Thanks a lot. And now we will, so thank you. And so now we will switch to the third lecture, but let me announce 10 minutes break for the real break and for the technological reasons. Thanks, Letizia, very much.
Thank you very much. It was a pleasure.
Thank you.